distinguished panelists and distinguished delegates, welcome to this afternoon's training session. My name is Tobena Erojikwe, and I'm the chairman of the board of the Institute of Continuing Legal Education. On behalf of the Institute, I welcome you all to today's training session. And I hope that you'll find it as illuminating as you expect. We already have about 6,000 people registered, and I can see that people are logging in as we speak. Thank you very much for your interest in this session, and thank you very much for encouraging and promoting the work that we do. This training is on criminal litigation and is going to last throughout the month of May, every Thursday, Friday, and Saturday. On Thursdays and Fridays, it will be between 2 p.m. and 4 p.m. On Saturdays, it will be between 12 p.m. or 12 noon and 2 p.m. We expect to run through this series very quickly, and we'll encourage you to ask as many questions as you need to or want to ask, but please do drop your questions in the Q&A box and not in the comment section so that it's easy to pick. Today we'll be talking about arrest and interrogation, the role of the legal practitioner. And I'll ask Mr. Tola Oshobi, Senior Advocate of Nigeria, to please introduce today's speaker, Mr. Dox Onyeke. Thank you very much. Tola, I yield the floor to you. Thank you.
Thank you very much, Chairman. I hope you can hear me clearly.
We can.
Okay, then. Yeah, the session for this afternoon is arrest and interrogation, the role of the legal practitioner, as stated by the chairman. Our speaker or facilitator is my dear brother, Edoka Onyeke, known as Dox. Mr. Edoka Dox Onyeke is the principal partner and managing counsel of the law firm of Onyeke, Ideho, and Igomwaye LP, a firm of legal practitioners involved in general legal practice with offices in Lagos and Port Harcourt. Mr. Onyeke is also a member of the International Bar Association, the American Bar Association, and the Lagos Court of Arbitration. Mr. Onyeke's areas of core competence are civil and criminal litigation, as well as investments and corporate legal advisory and documentation services. Mr. Onyeke is a respected criminal defense attorney and has been involved in the defense of criminal charges brought against several high net worth individuals, politically exposed persons, and corporate entities in the country. Mr. Onyeke has traveled widely in the course of providing legal advisory services on behalf of clients of the firm in the field of criminal litigation within and outside Nigeria, in countries like the United States, South Africa, Greece, United Arab Emirates, and Switzerland, amongst others. So Onyeke has also been involved in the provision of legal services in the area of criminal litigation, loan security and collateral documentation, debt realization for corporate organizations, banks, and other financial institutions in Nigeria. Mr. Onyeke has been involved in the provision of legal services in the area of receivership as an appointed receiver stroke manager for the recovery of toxic assets, as well as collateral realization on behalf of several financial institutions. Mr. Onyeke also designed and forwarded a proposed legal framework for the enforcement of the Cabotage Act by the Nigerian Maritime Administration and Safety Agency on the strict compliance with the legal and statutory restrictions imposed by the Cabotage Act on the operations of foreign-owned and flagged vessels in Nigeria, in Nigerian territorial waters, and was also one of the resource persons who designed the implementation of the justice reforms in the law and order sector of the Niger Delta Development Commission Master Plan for the Niger Delta State. Mr. Onyeke is also a non-executive director on the board of several companies and is happily married with children. Ladies and gentlemen, I present to you Mr. Dox Onyeke. He's my dear friend and brother. He's, for me, is one of the best criminal defense attorneys in the country. And when I have any serious or big issue in criminal defense, is one of my ports of call. So I think we have a very good, I know that right from the beginning we were call mates. I know that right from the beginning, he was very active in criminal litigation, and he has been very active in criminal litigation throughout his practice. So I think he's one of the best resource material for this particular session. Ladies and gentlemen, I introduce to you Mr. Dr. Onyeke. Thank you.
Thank you very much, fellow Shobi SAN. Those were very nice and kind words. Thank you very much for your good showing, as it were, in terms of what I represent. Thank you. Ladies and gentlemen, this session is about arrest and interrogation, the role of the legal practitioner. We will start by, first of all, making it clear that when we were all in law school, nobody really teaches you how to handle some of the things, the practical realities of what we see on the daily when, as lawyers, we go to either the police station or to a law enforcement agency office like the EFCC to conduct our job as lawyers. We always meet with some kind of hostility, and sometimes it has been reported that lawyers have been arrested, detained, and the NBA or the local branch has to intervene. So we deemed it necessary to say that you don't discuss criminal litigation without looking at where it all begins. It begins from when a person is arrested or invited. You know, these days they write you a letter and tell you to come and throw more lights on a matter under investigation. But we all know it's an euphemism for bring yourself down here so that we don't come after you. And of course, most times, once you make a statement under caution, you'll be placed under arrest, and then you have to start applying for administrative bail. So it was important in discussing this session on criminal litigation to go back to the very beginning and find out why do lawyers have problems when you go to a law enforcement agency office to perform your legitimate duties of providing legal services for your clients. And in doing this, we try to speak to as many as possible law enforcement officers to get their view as to why they always act the way they do when they see a lawyer coming. This is not a blanket accusation that all policemen or law enforcement agents are antagonistic towards lawyers. No, some are very, very respectful and very, very interesting to meet. But we all know that majority of them, once you introduce yourself as a lawyer, the first thing they do is they keep you waiting, and they try to find a way to ensure that they delay you and you end up spending the entire day either at the police station or in one of their offices. And of course, when it's time to interrogate your clients, they're always quick to tell you, lawyer, we are not asking you, asking your clients. So these are some of the challenges that our people face. So we ask most of them, why is this so? So what we are going to take us through in this session is the result and the combination of the answers we've gotten from these people over the years as to how we can better build a relationship between the law enforcement officers and the lawyers in the course of providing services, especially during interrogation, so that the lawyer can be effective in carrying out his duties. And in doing so, we would start with using the answers we got from them to create some kind of approach that we hope at the end of this session will be able to help our colleagues in carrying out their duties without feeling that they are going to be less effective when they go to the police station. Before doing this, I'd like to draw our attention to something. For a prosecutor, because this is not just about the defense, for a prosecutor, at the point of arrest and interrogation, that is where you either lose or win your case. And I will explain. If the investigator is able to properly investigate and follow all clues and all investigative outcomes in order to ensure that a proper investigation is done, the job of the prosecutor is made easy. It's just to go to court and present the evidence. However, where the investigating officer does not do a proper investigation, we all know the outcome, what the outcome will be in court. Of course, the defense counsel can pick it up, those mistakes, and use it to its advantage. Flipping it to the other side. In terms of the defense counsel, your ability to ensure that your client gives you something to work with during the proper trial after he has been charged starts from what you do during the course of his interrogation. And in this wise, I'm going to now separate it into two. The first one is this. You can represent people when, firstly, they are arrested without your being involved in the course of the arrest. Maybe they were caught carrying out a certain illegal act and they were arrested. That means you are called upon after the arrest to come and provide legal services. At that stage, you did not really have much time to have a briefing with your client in case he's written an extrajudicial statement. However, if it's a case where he was invited by way of a letter sent to him, please come and meet us at our office. We are investigating the matter. We need you to throw more light. It gives the practitioner sufficient time to meet with the client, and between the two of them, take a look at his transactions and find out what would be the reason for the arrest or for the invitation. And it's at that point that we always advise that lawyers should try as much as possible to develop scenarios of responses to any kind of question that may likely arise in the course of interrogation. And the importance will be seen very soon. When you prepare your client very well before he honors that invitation, as a lawyer, you would need not do so much in terms of intervening when he's being interrogated. Because it is that intervention that we've been told has caused a lot of problem between lawyers and law enforcement agents, because they view your intervention as trying to interfere with their work. And then you hear comments like, this is not a court, don't come here and quote law for us. It's simply because you are afraid your client will say something that could make it terribly impossible for you to defend him. So these situations are what we are trying to guard against. Firstly, how to prepare your clients properly so that if you have the opportunity of having a sit down with him, explain to him what, after telling you his story, explain to him what you expect him to do when questions of a certain nature are asked, without you having to provide the answers for him or nudging him on what he should respond to. He should be able to answer his question so that the focus will be on him rather than on you. And once the focus is on him, your job has been 90% done, because at that stage, you will just be ensuring that nobody bullies him into answering. That's all you can do. And at that stage, nobody would interfere with you if you are going to stop somebody from bullying your client. But it is when you try to stop your client from answering a question that causes a problem between lawyers and law enforcement agents. And that is something that happens almost every time when you ask any law enforcement officer why they have a challenge with lawyers. Now, on the screen, you will see that our introductory position is that the right of arrest, detention, and interrogation of persons. This is a right that the police has. The police has a right to detain people, to arrest people, and to interrogate people. So we have a situation where the police as a body has a right to carry out, when I say police, I'm not talking generally about law enforcement agents, because those other agencies like the ICPC, the EFCC, even customs, their enabling statutes also gives them the right to arrest persons in line with their own, within their jurisdictional areas of enforcement. So if they have this right, as a lawyer, it's not your duty to go there and make it seem as if they do not have the right. The right they don't have is to deny your clients of the constitutional rights to counsel of their choice, which Section 35(2) of the Constitution provides, and Section 2A, B, and C of the Administration of Criminal Justice Acts 2015, as well as Section 9, 2, and 3 of the Administration of Criminal Justice Law of Lagos State. I also am aware that most of the other states that have their own Administration of Criminal Justice Law also have provision for suspects or persons arrested to have a right of counsel of their choice. So this is a right that is both constitutionally guaranteed and statutorily guaranteed. So we have two rights here: the right of the police to arrest, detain, and interrogate, and the right of the persons arrested to legal counsel of their choice before making any statement. So it is the way we make sure that we balance it properly, creates the effectiveness of a counsel. Now, realities of how a legal practitioner can effectively perform his role and legal responsibility during interrogation. In my introductory aspects, I mentioned issues concerning the relationship between police and lawyers, and what are the kind of responses we've gotten from them in our research as to why is law enforcement agents are always antagonistic towards lawyers. So what they've told us, we've narrowed it down to some kind of module, which is now part of this presentation, which we call the practical realities. This cannot be seen in any book. This is not in any law book. This is not, we are not taught this at law school, university, nobody teaches all this. This is on practical realities. And we start with the issue of composure. Talking about composure, comportment, courage, charm, offensive. Let's take composure. Most law enforcement officers, almost all of them that we interviewed, are unanimous that the way a lawyer is composed is the way they address him. If you go to a law enforcement office, for instance, let's say the police station, and you are addressed as a lawyer in a manner that is not very, very inviting or respectful, 9 times out of 10, the policeman will not countenance with you. You see, something as little as the way you dress is important in the way they respect you. And we have colleagues who they run away from, they leave the court, from the court, they just wear their petticoat and trouser with their shirts. Maybe the heat of the day has really done a number on them. And they go to the police station. Some, the trousers are threadbare, the coat is threadbare. And once the policeman cites this, your looks, the kind of respect they want to give to you starts dropping. You may not know this. These are the uncertain things, and what our research has unheaded. The dress matters a lot. If you are dressed respectfully in a good suit, I'm not saying that all lawyers are doing so well to enforce, but I believe that a lawyer should be able to afford a suit that he can wear to a place like that. When you go there, your presence, first of all, gives you invitation to come in without somebody antagonizing you. The next thing is comportment. Most lawyers go to places like that. I'm not saying all, but this is one of the outcome of the research. That you go to a police station, for instance, you want to go there and look down on everybody. The policemen, this is their office. They will defend their office. They are armed men. They will defend their office. They don't want you to come there and tell them what to do. If you are going to mess them up, because that's your own office, but not in their office. So you have to give them respect. Now, comportment in this regard expects that you go and go to the law enforcement office, you give everybody their due respect. Do not lord it over anybody. Do not be condescending in the way you approach people. When you do this, you begin to get from your composure in terms of the way you are dressed to the way you now carry yourself there. You discover that you are already breaking down the barriers. The barriers you are breaking are the barriers of somebody who is, they are expecting you to come in charging into the place. Right now, what you are doing is you are dousing the tension, making them see that you are sociable and accessible. You are not here to tell them what to do. You are just here to perform a service for your clients. You respect their job. You are not going to tell them what to do and all that stuff. This is very important because this is what they are looking out for. They are looking out for somebody who is coming to come and tell them that I'm a TV lawyer, I'm going to sue you, nobody wants to hear that. Once you start that from the gates, they will put you in your place. So you look at courage. Comportment and courage are very close cousins, if I'm allowed to say so. A lawyer should carry himself in a manner that shows his training. You must be aware of the nature of the work you're about to do and the fact that someone is depending on you to provide services that would be beneficial to him. So as a lawyer, when you go to a law enforcement office, keep your eye on the ball. Carry yourself in a manner that gives respect to not only your person, but demands respect for your person. And in doing so, do not begin to make it look as if that respect you are demanding it. No, the respect will come naturally if you carry yourself properly. It is not something you go to a police station and demand that it should be given to you. Nobody will give it to you. Instead, you just make yourself ineffective for your client, because at the end of the day, the policeman will say, want to rubbish you. And this is what they do. They just want to rubbish you so that they put you in your place according to them. Yes, you might end up succeeding in a fundamental human rights action and all that stuff. But who suffers? It is your client that will suffer for that moment. So this brings us to the fourth C, which is charm offensive. The charm offensive is that you are the one who wants something done for you. Don't go there, and I keep repeating this, don't go there making it seem as if it's a matter of right. Yes, there are statutory rights that your clients enjoy. But whilst there, to convey those rights to the body, the person, you need to clear to them that you respect them as well, because they have a right as well to your client and demand some answers from him. So you must be able to balance your client's rights with their rights. And in doing so, you must be seen not to be negative in the way you approach them. The charm offensive means that you are filled with smiles. You are not trying to wear a face of somebody who believes that he's not supposed to be there. You are playing with everybody there. You are respectful to everybody, up to the lowest officer, because nobody is small there at that point. You are using the appropriate courteous words, sir, ma, and all the rest of everybody. This brings down tension. I've never gone to a law enforcement office and they walk me out of any office. They won't, because I know my place. No matter how well dressed or how expensive looking I am, when I go to a place like that, using myself as an example, I respect everybody I come across, from the cleaner to the man investigating to the boss of the man investigating. Give everybody their respect. And you discover that at the end of the day, they are the ones who will be holding you up to a higher pedestal. So this brings us to the first item I was discussing concerning the skills to be deployed for effective representation of clients during interrogation. Like I mentioned before, there are two instances where a client could be subject to an arrest. The first is when he's arrested directly whilst he's either alleged to be committing the offense, or the police just goes to his place and arrest him based on a complaint. The second scenario is when invitation letters are sent. Now, the first scenario may not give you sufficient time to prepare your client for interrogation. But if that occurs, now looking at the first scenario, if it occurs that you were briefed after the client has been arrested, I expect that the first thing a lawyer should do in order to be effective is to go and visit the client where he's detained. Have a meeting with him. Know from him what he said, if he has made any extrajudicial statement or not. Now, if he has made an extrajudicial statement, it's important at that point, after hearing his whole side of the story, to ask him a very straight question. If what he's told you about the true nature of the events is what he wrote there in his statement. If he tells you that, oh, I said that, but they refused to accept that position, they accepted this, they said it must be something else that is incriminating that they will accept. At that point in time, be very calm. Do not try as much as possible to go and confront the officers. You are still trying to win them over to your position. Brief your client and make him understand that he should insist that next time he's not going to write an statement without his lawyer present, now that a lawyer has come in for him. So that at that point, any statement that he makes in your presence, insist on signing it with him. The reason you are insisting on signing it, there's a provision for a client, the witness to the statement to sign in that extrajudicial statement, sign it. If you need to do a trial sometime in the future during a trial, if he's charged to court, your signing every other statement he made in your presence is going to be critical in getting the court to throw out the first statement. This is because you can at that point draw the court's attention to the provisions of the law that says he should have somebody present when he's making a statement, and insist that when you came in, this was what happened and this is what you did. So you're signing all others, which you are not going to be contesting or objecting to, will give the court an idea as to what must have happened, especially when other pieces of evidence don't fit the first extrajudicial statement. So you see, you are going to achieve the same thing without necessarily confronting or being confrontational. Now, with respect to the second part, which is your client is issued an invitation and you had an opportunity to sit down with him. Like I said before, have a sit down with him, hear his own side of the story, listen very, very attentively to him. develop a strategy for responses to all kinds of questions that may come up in the course of interrogation. Then visit honor the invitation, and as much as possible, just do a hand-holding exercise where a statement form is brought, your client is cautioned, and is asked to is confronted with the allegation by way of petition or whatever way manner the complaint was made against him, and he writes his own narration in his own words, on his own way, what his response is to each of those allegations made against him. Now, at that point, since both of you already have had a trial run on what scenarios could occur and responses to those scenarios, you will discover that as a lawyer, you are not interfering with the process. You are just sitting down, your client is writing. And at that point, you are making friends with the investigators. They are seeing you as just part of a process that ought to be, not somebody who's a log in the wheel of progress. So you are sitting down there. You've done your work before you guys came in there. You don't need to get up and say, oh, why is this writing this? Why is he not writing this? No, don't ask him, doctor. Don't need for all that. These are the things that cause friction between law enforcement officers and lawyers. Because as a lawyer, your first instinct is to try and protect your client from making incriminating statements. There's no need for this. Do your own work before you go to visit the station. If you require more time before you enter the visitation, write to them. Most times, they always accept your extension, so long as you don't abuse it. You do all your stuff, go with your documents in case you have documents that support your client's position. Encourage him to come with it. So as he's asked the question, you provide those documents to solidify his position. 9 times out of 10, those kind of cases, they hardly go anywhere. Or if at all they have to progress, you'll have a better chance at trial. Now, if you look at the second aspect, which is avoid as much as possible interference, which is exactly what I've been saying since. This is where the problem between the police and the lawyers occur. This perceived notion that we interfere with the actual interrogation process. Lawyers, by nature, will not sit back when their client is making a statement or answering a question that will incriminate them. It's just not part of our DNA. We are wired to respond. Now, if you can avoid interfering with the process, you are already getting an effective representation of your client. And this is why I've just told us how we can avoid interfering with the process. Prepare your client ahead of time. Now, if you look at the third one, it said develop a rapport to avoid or minimize hostility during interrogation. Investigators are human beings. They want to be respected. I, for one, believe that a lot of lawyers should develop what I call social skills, personable skills, where you can go into an environment where you know nobody. Within a space of 1 hour, you're already unfriendly and good talking terms with people there. This will help you a lot. See, an investigator looks at both you and your client as people who have come to lie to them or to derail his investigation. So what do? The moment you get into that place, introduce yourself. If you have a card to exchange cards, you start with trying as much as possible to show those social skills that we ought to have and deploy at this point in making sure that the investigator has a relationship or develops a relationship with you that does not make him hostile to you or towards you during the course of interrogation of your client. And this you can do by limiting your role as a lawyer and playing up your role as a human being who is just there to assist one human being, because that toga of lawyer is what they are worried about. So you don't want to be telling your clients, let me see, what is he asking you to sign? Those are not necessary. You can actually see those things without necessarily voicing it out. And this is one of the things we should have in our skill, in our armory, the ability to talk to our client without necessarily saying things from our words. If you want to develop some kind of sign language, you develop it. That's why you prepared him before you went to the station. As much as possible, make yourself invisible while you are visible. Now, if you look at the fourth one, do not provide answers and or respond to questions meant for your client. This is critical. And it brings us back to the issue of preparedness. Some lawyers, from the answers we got from the law enforcement agents that we interacted with over time, some lawyers, the first thing they do when questions are asked, as the client is answering, they are completing the sentence for the client so that they believe the client would forget what they've agreed you should say. So the lawyers want to provide the answer and remind the client on how to answer. Once you do this 3-4 times, the investigator will tell you, lawyer, I think you should go and sit over there. And the moment you have been removed from where your client is making a statement to maybe a few meters away where you can see him, but you are not near him, you've not only reduced your client's confidence in the entire process, you have made him anxious and you've become ineffective, because the things you could have maybe nudged him not to do quietly, you will now not be able to do it because you are away from the scene. So don't avoid providing any answer of any kind. Once a question is meant for your client, allow him to be the one to answer it. Once he's answering it, even if he's fidgeting in the course of answering it, it's a natural thing that when you're in such a tense environment, half the thing you are told you forget. But as the interrogation progresses, your client will come into his own confidence. And once he comes to his own confidence, whatever preparation you've done to him, he will be able to deploy it. At that stage, you are now doing what you ought to do without necessarily disrupting the process, and you are there. Now, if you look at the next item, which is avoid being seen through your actions during interrogation as a clog in the way. Of course, this is what we've been saying all along. Your action during the course of interrogation matters a lot. Sign language that is visible to the investigative officer should be avoided as much as possible. Holding your client's hand and telling him not to answer this question, those are things you should not do. Shouting at the investigator, asking him why he's asking this question, oh, your client has answered it, why is he asking it the second time? There's no need for all that. Even when you do that, even when you tell the investigator, he has responded to this question again, don't ask him again. There is a way you can go about doing it if you develop the rapport, as mentioned in the third bullet point on this shared screen. Once you develop a rapport, your ability to even start interfering quietly in the process, the investigator will not even notice it anymore. This is because the focus is no longer on you, but now on what he's doing, which is important. Initially, you come in with your client, the focus is on how to take you out so that they can do the investigation, because they know that with you there, it will be difficult to ask your client some questions. But if you do what you have to do, at a point in time, you'll be the one in control of the whole exercise without necessarily being seen to be so, but you will be. Then avoid any action that could raise any suspicion or lead to any adverse conclusion on your role or presence during interrogation. This was a major complaint that the lawyers, they believe that this place is their office. The office of the police or the office of the law enforcement agent is not the lawyer's office. You do not have a right to come in there and start creating room to turning that place a session of either your office or the court. In present-day Nigeria, no policeman wants to be told what to do in their office. So it's important that you avoid those kind of actions. Now, how do you go about this? Because it's one thing to say, oh, don't do this, don't do this. But some people are not wired to take these lessons or to act in this way. So we've taken the pains to say, okay, if these are the things that they quarrel against, that's the investigators quarrel against, that's the problem they always have with lawyers. How do we get our colleagues to turn the corner or turn a new leaf and act in a manner that makes them effective or able to effectively deliver their services to their clients? The first thing you need to do is be subtle in your approach. Do not be aggressive. Be calm, firm, and respectful all throughout. You see, once you are subtle, you are calm, and you are respectful, once you display these three qualities, I assure you, it will be difficult to quarrel with you, because a man who is not quarreling with somebody cannot be the source of an antagonistic behavior. If the policeman wants to quarrel and you are just calm, the question will not, his own colleagues will tell him, this man is not troubling. Why are you making all this noise there now? Because at the end of the day, it is him that will stand out as the person who is causing the problem in the investigation, not you. So you must be subtle in your approach towards either your client doing certain things or the officers asking him not to do certain things. Do not impose yourself on the process. That's the point I'm trying to make. You should also be calm. The calmness comes from provocation. As a lawyer, a lot of things will not make sense to you. We do our job in fact, our job is dictated by logic. Now, if you go to a place where the man's actions are not logical, it could be out of a deliberate act not to be logical on his part, because he needs to take you out of the place so that he can do what he wants to do to your client. So you must be calm from any provocation that he wants to throw your way. He's going to provoke you. I can assure you that you get provoked by these people. So the provocation can be done in a manner that it is one of the policemen that has been assigned to ensure that they provoke you. While you are focusing on fighting that one, someone is talking with your client. You're not even effective anymore. You don't even know why you're there anymore. So you must be calm, you must be firm, and you must be respectful. And once you display these attitudes, the tension in the room will come down, you do your job. If you look at the second line, do not be arrogant, combative, or engage in arguments, which of course flows from what I've just said before. You see, it is easy for the policeman to see your confidence as a lawyer as arrogance. So you must be able to find a way to ensure that you're not viewed as being arrogant. Because once you're arrogant, the policeman who believes that maybe your learning is higher than his, and you want to come there and tell him, he will tell you that I've been doing this job for like 25 years. If I had been a lawyer, I would have gone very far. Those are the kind of comments you hear. And as they adopt that attitude, you are not going to be able to effectively represent your clients. So avoid anything that make anyone to view you as being arrogant. Do not be combative. Do not engage in arguments with your investigating officer. This is very important. I have seen situations where, personally, we are in an interrogation room. A lawyer on the other, just some few meters away, is busy engaging in arguments with the investigative officer over the way and manner he was conducting his interrogation. We finished our exercise and left there. They were still there. And of course, it was obvious that his client is not going to go home that day. So what they will do is that you finish all your provocation. They'll tell you that they want to detain your client. Make sure they give you a bail condition that you cannot meet immediately. You go and be looking for that to meet the bail condition. In the night when you're not there, they will call up your client and they will do what they want to do without you being there. This is the reality of what happens. So for you to avoid all those kind of situations, you must learn not to engage in any form of argument with the police officers. And once you are being provoked to an argument, just find a simple joke or something to clean it over, because you are not there for you. It's your ego is not at play here. It's your client's liberty that is at stake. So you must be able to lift yourself above any kind of provocation. Now, also, on the issue of arrogance can also be linked to the third paragraph there, which is avoid being construed as stuck up or full of your own importance. You see some lawyers, they wear this toga of lawyer, they take it too seriously. And I say that with all sense of responsibility. You go to a police station or you go to a law enforcement agent's office, everybody must know that you're a lawyer. Why? You see, the moment you are stuck up and full of your own importance, you may just rub somebody off the wrong way. And the next thing, amongst themselves, they will take a decision that, you know what, this man's client is not going today. Let's deal with him. And this is what happens. It's not the right thing to do. Obviously, we have a lot to learn. We have a lot of improvements that we need in our system in the country, but we need to do it step by step. And one of the ways we can do it is also to remove the log in our eye before we look at the needle in another man's eye. This idea of a lawyer trying to feel that he's more important than everybody when he goes to a police station should stop. You are going to visit somebody in his office. Let's assume you're a contractor. You want to go to a ministry to get a contract. You won't go there and be telling them I'm a contractor, I've successfully built houses, I've successfully built roads, the contract is mine as of right. No, you will still go there with all humility because you know that there are people who are contesting for that contract. So you need to be seen favorably before you can get it. That's the same way you should treat yourself as a lawyer is going to a police station to act for your client. It's your client that's the issue here, not you. So you must learn to avoid being stuck up. Do not make it look at it as if your client you are doing him a favor by coming. No, he's paying you a fee. So your importance is of no importance. And this certain, if you mind my play on words there, it is the liberty of a client that's important. Try not to be wearing it in your face that you are a lawyer, you must do this. Once you quote the law, this will happen. No. Then you look at the last line, be flexible in navigating any unfriendly attitude. It comes, you see all these behavioral patterns that we're asking you lawyers to adopt. You see, they flow into each other. You cannot go into an environment of that nature without being flexible in the way and friendly. You go there because your client told you one or two things that one policeman has done to him. You are reeking in your mind. You are reeling in your mind with anger about what you're going to do to them, and then you get there. Any small thing that looks untoward, you flare up. No need for that. You must be flexible. You must be friendly. Remove all sorts. When you get your client out of there, there are recourse that you can have in law for any conduct that has been done to your client or anything that has been done to your client. So, but you must not, while there, it's like being in the lion's den and trying to steal, instead of looking for an escape route, you are still there trying to stay there and waste your time there. And of course, the lion will eat you up. So you need to wear that friendly disposition and find a way to navigate your way around any negativity around the place so that you can become effective as a lawyer. Also speaking about conduct, you see, lawyers must learn to exhibit good social and personable skills in their interaction with law enforcement agents and with investigating officers during interrogation. This is key. This is key because if you are seen as a lawyer who is always very friendly and who does not antagonize them, anytime you come to their formation to carry out your services, nobody will disturb you. You will just be like one of the guys. You are already effective because at that stage, it is clear that your presence is not seen as a threat to the investigation. But sincerely speaking, you are going to be more effective in ensuring that anything that happens thereafter, your client's interests will be protected. Now, your actions, which brings me to the second paragraph, your actions during the interrogation is also important. You must not be construed in any way as attempting to take over the interrogation process. And I'll give you an example. Your client is asked a question. You don't like the question, or you feel he's not going to be able to answer the question, perhaps because in answering it, he's going to say more than you want him to say. Just relax. You've prepared your client. Allow your client to do what he has to do. He also is to a large extent, it depends on the client you are representing. If he's not somebody who does not have, I would say, some kind of educational skills, it's important that that is made clear in the very beginning to the investigative officer, that break down the question such a way that he understands what you are asking of him before he puts his response down on paper. Or at best, you tell them you are going to write for him, let him answer them. That way, your writing it now depends on the way you understand what he's saying or what he has said. So as a matter of necessity, you must not antagonize or overwhelm the investigative officers for him to begin to think that you are now there to take over his job. Once he perceives you as such a person, the first thing he's going to do is to ensure that you are out of the office. Or he will report you to a superior officer who will come and tell you, please, lawyer, we know you're supposed to be here, but no law says you should interfere with what we are doing. Sit chair here, sit down there. You are supposed to observe what we are doing, not to sit by him. The right to sit by him when he's writing his statement, they believe it is their right, which is privilege rather, which they are giving to you. But you can sit on one end watching what is happening and ensuring that tomorrow you can say, oh, he was there, the lawyer was present, nobody bullied him, nobody coerced him into writing anything he's saying. This is important. Now, if you go to the last paragraph there, endeavor to build and maintain good working relationship. You see, some of us, until we have, you are practicing in locale. You have the police formation division there near your office. You have area command near your office. Some even have the state headquarters near them. If you know your practice is tilted towards criminal litigation, which will give you an opportunity to be going to some of these places, I expect you as a lawyer to begin to develop relationship with key officers in those formations. This is very important because once you develop relationships, a good working relationship with law enforcement agents, those kind of widely held views about lawyers that are negative begins to come down. It begins to come down where you are concerned and where you are representing a person. Instead, they will be the one to tell you, this is your client. Talk to Ramo, this thing you do not good. Though. Immediately they start talking to you like that. Obviously, a resolution is in the offing, because it means that they trust you to relate with your clients and bring about an acceptable outcome in the course of their duty. Because obviously with the new Police Act, I think they have a right to do ADRO, resolve some issues within their formation. So these are the things you need to do. You don't go to the police station because you believe that everybody there they are just useless people. No need for that. They are human beings. Make them feel important. Develop relationships with them that will help you in the future. Please, next slide. Now, administrative bail. This is one area that we have a challenge with. Most of us who are conversant with going to places like the EFCC, the ICPC, and some of these formations have this, even the SFU, and I think some of these police formations that are like Alago and Co. They have this form they give to you when it comes down to the issue of bail, where they ask you to bring somebody who's a civil servant, landowner, and all the rest. Sometimes very ridiculous requests. They are not a court. All they need is somebody that can bring you anytime they need you. But they've turned themselves, because they want to keep your man, they've drawn up some conditions that, like, as if they are a court. It doesn't matter. What is important is that if you build the relationships that I just mentioned just in the previous slide, you discover that all those things, you don't even need to provide those things for them to release your client to you. And I say this is also a responsibility. They can give you the form for the purpose of meeting their usual administrative requirements. But if you bring somebody who is responsible, who has verifiable address that anybody can say, oh, that's where he stays, we know him, they will release your client to you without force. The problem really is you as a lawyer must make sure that whoever you are bringing is of good standing and verifiable credentials. This is not a forum where we can go into a lot of things that happen behind the scene with respect to the kind of people that are presented as sureties by some of our colleagues, just to be able to get the client out at all costs. But this is not the forum for that. But the fact remains that if you know your client is likely to be arrested, or you make a statement on that caution, obviously it's going to be released on administrative bail. You must begin to look for people who can at least who are presentable, who have good credentials to present to them. Say, look, I can't meet this condition of landowner in Ikoyi or in one of these expensive places as the sometimes a system if they want to be very, very naughty. What I can do is I can bring somebody who is a respected member of the society to come and stand as a surety, and the man will bring him each time you require him. This can be done. Now, if for any reason the IPO decides not to cooperate with you in this regard, you can make, he's not cooperating with you. This brings us to the second one about, no, please go back to the slide. Now, if you go back to the second line of that, the second paragraph says, establishing a good rapport with the investigative officer will be of great assistance in acceptance of persons proposed as sureties. Yes, if you do what you need to do in the course of the interrogation of your client during the course of the whole exercise, you were not a clog, you were friendly and everything, you discover that the investigating officer, when it gets to the issue of sureties, would most likely work with you to present the sureties and the recommendation for bail to his superior officers. 9 times out of 10, the superior officer is not interested in who acts as surety. That is the prerogative of the investigating officer. He only goes to him with the form to say, this man has brought sureties, they are okay, I'm okay with it. It is his case, he's the one investigating, he's the one that will call you up. But when he does not do what he has to do, that's when you need probably to seek superior officer to intervene. But even when you know that the investigative officer is trying to be funny, I don't recommend that you should antagonize him. Try and make it look like he's only doing his job. He would assist you the best way he can, even though you know it's the cause of the plug in your clients being released. you need to play it very cool. Ask him to tell you what will work. Propose to him what you think should work, and then seek his assistance and recommendation to go to his superior officer to see if he can join you begging his superior officer to agree, because he will always tell you, oh, it's my guy that said this, is my guy that said. So beg him now to allow you see his superior officer with him. Don't make it look as if you are aware that he is the one creating the problem, because that is his job, to make sure that you go home, your client remains detained, then he can carry out his business. But where he fails to do so, approach his superior officer, and when you are telling him about the issue of bail, try not to make it seem as if you are reporting the man. A lot of our colleagues do this. They go to his superior officer, they try to make it seem as if that guy that has been very difficult, they need to report it. The superior officer is not going to sack the investigative officer. He's not going to remove him from the case. So there's no point creating an enemy where you don't need one. Go to the superior officer, say nice things about the IPO, that, oh, he has even tried, he has been really nice, I like the way he has approached the matter, he's been fair, even if he has been none of these things. And then request him to look at the shorties you are proposing. At that stage, you have not spoken ill of his officers. You seem to be doing well the process. He will call the man and ask the man, what is happening? What is this? In between that discussion, if he decides to open up himself to his superior by being difficult, remember that you just praised him. He was not there. And now he is the one trying to now be the opposite of what you called him. Of course, the officer will see through the old charade and immediately will say, okay, you know what? Can you provide this? Obviously, that's a progress. From where you are to what is now proposing is progress. Take what you can and go and meet the conditions and have your clients released. Next slide, please. Now, this aspect has to do with before you even approach the officer with respect to the reviewing of the condition of bail. Some of us are very difficult when there is an opposing view to what is happening. For instance, we propose that lawyers should always learn to listen and be patient. If the officer is saying, I don't want to accept this your surety, what is the reason? Try and coax it out of him. And this you can do because I've had a situation where a man stood surety for somebody. There was a problem, a very big problem. And that same person wanted to stand as surety for another person again. Of course, I didn't know about the previous one because I was not the one handling that matter. And when they said they wouldn't take this person, and I was told this was the reason. Obviously, immediately I put that person aside. But if you keep insisting, it creates the impression that you already are aware and you want what happened before to happen again. But the moment you agree with him and then look for acceptable alternative, you discover that there will be no point of conflict between the two of you. The idea is to provide what is acceptable to them, or as close as close as possible to what they are asking you for your client to go. Once he is released on bail, the tension that has been generated by his arrest and interrogation would simmer down. Now you can now begin to look at the possibility of either resolving the matter over there or ensuring that if at all the matter is going to go to to court, you are preparing for how to defend your client. Because obviously the difficult periods in an arrest and interrogation is the detention part. Once you have resolved that detention part, you don't even have to be going there every day with your client if it's the type that is going to be signing register. And talking about signing of register, if his bail condition is one that requires him to be signing the register either at his police station or at a law enforcement agency office, as much as possible, we encourage our clients, we should encourage the client to meet those conditions. Some lawyers, they come in, get the bail done, and then they don't even call up the client again. They've done their own bid. They only called in to babysit the client for that period, they move on. What you don't understand is that once you are associated with a particular client or a particular investigation, yes, you are just acted as a lawyer, you did not stand as surety, so if anything happens, nobody's going to come and hold you. However, you may come back there tomorrow. If you come back there tomorrow for another client, you might have forgotten the first client that you brought there, in the sense that you did not follow up the events that occurred. But they have not forgotten. Maybe the client jumped bail or it became something different. They will still view you with the way they view that person, such that even this new client that is a very good person, you are going to have a challenge getting him the proper legal remedy that he requires, or be effective as a legal practitioner to him, because of the way they are viewing you over the other matter. So it's important that as a lawyer, you try as much as possible to make it clear to your client that you do not want him or her to breach any of his bail conditions. He should always be seen as being responsive to them. When he calls them, when they call him up at any point in time, he should respond. He should not be rude to them. And at the end of the day, his conduct is a reflection on the respect that is given to you. I think that summarizes our presentation with respect to when he's arrested and when he's interrogated, and of course, when he gets bail. This is in no way exhaustive of all that happens at the police station. I must tell us that we don't have a one-size-fits-all solution, but we believe that your ability as a lawyer to provide effective service for your client in a police formation or in any law enforcement office is 90% dependent on your ability as a lawyer to show and display your people and social skills, not necessarily your legal skills. Your legal skills have no basis there. It only makes you to sit there as a lawyer and know how to make sure that your client is not unnecessarily jeopardized. But it is your social skills in handling persons that matters most. So those of us who are lacking in tact, wisdom, and people skills on how to surmount challenges posed to us in the course of our duties, we should go and learn it. I'm saying this as a matter of very serious necessity. You cannot surmount problems that people like that put in your front without necessarily learning how to handle issues. If you are of short temper, you get easily angered, easily provoked, and easily wound up, you have no business offering any of these services to a client at the police station, because the simplest way to get you out is to provoke you, and they will do it. So I will be rounding up by saying that I hope that when we are engaged to provide legal services for clients at those such as a police formation or any of those places, that we will try as much as possible to up our social skills, to apply our legal skills, and don't bring our ego into the mix. Thank you very much.
Docs, very incisive. We'll keep our comments at the end of the session. Before going to question time, I'd like to invite some of the other speakers or tutors for the series to make their comments. I'll first call on Professor Nasiru Ali, Senior Advocate of Nigeria. Prof, what are your comments on Doc's lecture, and do you have any practical experiences that you want to share that might help elucidate the points that were made? Thank you.
Thank you very much, Mr. Chair. I would say it's a precise, concise, and very insightful, and I can see the experience flowing from Doctor, and I really enjoyed the presentation. And like when Doctor is speaking, like yes, he's speaking my mind. You know, we will, as lawyers, always be insisting on our constitutional right. Now, if you look at it critically, that when your client is before a police or any investigative agencies, now what is expected, for example, what you will be reading in a book and then in the Western world, that a client is expected to have even a discussion with his lawyer when a question is been asked. But certainly in Nigeria, it's never like that. Now, by the time you are trying to intrude or to like go into like telling a client, I have an experience. You know, just the way Dr. said that we should be tactful and then be respectful, that you find some of these investigative agencies themselves, they're very, very clever people. And then to the extent that they will sway the mind of your client. I can remember an experience, a very, very serious case, and a very, very senior citizen of Nigeria. We were representing, led by a very senior advocate of Nigeria, very senior one. We were talking to our client, but the client was saying, look, this gentleman has been very good to me. But remember, what we realized, he had made so much confessions. So you can see, instead of you as a lawyer, for example, if you don't prepare your client very well, then your client will end up giving you up. So when we were trying to talk to the client, because we were unable to see him before to prepare him. So the point I'm trying to make is that just the way some of these investigators are very professional and try to sway the mind of your client in thinking that, in fact, they are even doing in his own interest. So at the same time, we should also try to develop that skill as just explained by Dr. Nweke. So I thank you very much for the opportunity.
Thank you very much, Prof. Thank you for your comments. May I now invite Dr. James Agaba for his comments.
Yeah, thank you very much, Chairman. I must thank Mr. Dodd so much for that incisive discourse we've had. And as a teacher, as I sat back, I was just laughing to myself. When we had, I don't know whether you remember that discussion earlier on when he said, no, in less than 30 minutes, I'll be through. And all of that, assuming that he used less than 30 minutes, we would have lost all that he had, most half of what he had told us. I don't think there's anything he said that we can say we didn't benefit from, or like younger ones too didn't benefit from. So it's not always easy to say, no, I am going to cut off. I'll just cut you cut off some things and you almost take up everything. So it's quite good. And for those of us who are listening, particularly for the younger ones, he said something which is very fundamental. It is not about your ego as a lawyer. It's about the client. If we remember that it's all about the client, we'll do all that we need to do. We'll be able to act as sponge and soak in any provocation that the police or the law enforcement agents give us in the course of trying to release our client. Don't forget that the SO have latitude. Ordinarily, for some offenses, they've said they have 48 hours beyond which they will not have to detain them. But in some other serious cases, you know it will be longer. But assuming it's even the 48 hours, it's a whole lot. If you're going to the station and you don't want your client to sleep there, even for simple offenses, and you are blowing grammar, you are a constitutional right, is this, is that, they could play you up to Friday. If they like, they can just they will just release him for you now. On Friday, they pick him up again for further investigation. And that means that it's on Monday that you're going to get him. If you talk too much, you're going to fight fundamental rights action in court. But then until the court answer you, the same police will not answer you again. You know, and of course, some of the damages you have also gotten against the police. How many of them have we recovered? So I think it's good to have that social skills. Consider that, oh, it's not about our ego, it's not about ourselves, it's actually about the interests of the client. Whatever you can do to let him not stay there longer than he ought will help a whole great deal. Thank you so much once again, Mr. Dox, for that beautiful presentation. Thank you.
Thank you, Doc. I can see that some of your former students are very excited to see you. They're also excited to see Professor Nasir and you. So technology had a way of bringing us together, right? May I now call on Mrs. Cornelia Eke. Madam, your comment.
Okay, thank you very much, Mr. Chairman. Now, Dr. said a lot of things that are very germane, but I just want to say something, and that is about some situations where the police officers can actually go overboard. There are some officers that you cannot placate. Some seem to have a mission to accomplish, and however nice the lawyer is, they just want to be difficult. So in certain instances, when the lawyer has done what you ought to do, and you suspect that there is something going on behind the scenes, I think the lawyer has every right to write, to see how he can move that case out of that police station. You go right to the CP, or is it to the area command, look for a higher, another officer or another station that can take over the case from where it is. Because there are some officers that truly can be difficult. So even your social skills may really not save your client. So I just want to throw that in, that we can, of course, just decide to apply, do a petition and ask that the case be transferred. Sometimes it may cost your client, a day or two. It's not so nice, but sometimes at the end of the day, you may achieve more by just doing that petition and asking that the case be transferred to a superior officer, another police station. Look, there have been instances where even in working with civil society, we've actually got a DPO arrested. Sometimes the DPO or DCO may be complicit in what is going on, and the lawyer does not know about it. So we've actually got a CP to order the arrest of a DPO because of a case that was being manipulated, and they just refused to allow the lawyers, to have access to their clients and refused to release the suspect. So that is also available. And let's not forget the Police Service Commission is also there. So lawyers are not necessarily without remedy. Thank you. That's all I just wanted to say.
Thank you, Mrs. Eke. Docs, I think you have to have the right of reply on this one, because I think it's a very serious point that's been raised. Situations where people are arrested probably because there's been some corruption or some compromise on the part of police officers. Docs, do you agree with Mrs. Eke's perspective, or do you have any more ingenious way of dealing with these kind of situations? Docs, you're muted.
Let me first of all thank my fellow facilitators and resource persons for their wonderful input. It's like I said before, our presentation was not exhaustive of the situation, and we all know that we cannot be exhaustive of approaches in this kind of time-bound forum. With respect to a situation where there was a preconceived arrangement to punish somebody, the approach that I've suggested would not be different, to say to a large extent, which is play it cool, understand what is happening, and then of course implement what Mrs. Eke has just mentioned. There are so many ways a lawyer can make life difficult for some police formation or a law enforcement body that is trying to do things like that. You could take the whole matter out of them by going to court. Let me explain. If your client is being detained unnecessarily, we all know that under the new provisions of the ACJA, they came up with this 30-day detention application that police can go to a magistrate court, apply for a further extension beyond 48 hours while they investigate. The first one they do without, most times they do that without even ex parte. And they try to convince the magistrate why he should order an extension of the detention of the person so that they can legitimize that particular detention. It is the position of the law that they followed, but of course, we all know that they are doing it negatively. Now, I also know that the provision of that same law allows for a review, I think after about 7 days or so. What they normally do, the first 7 days you detain, and then you come back again to know whether they should extend it or not. And here in Lagos, a lot of magistrates have refused to extend when there is obviously no reason for such an extension, because it becomes clear at that point that the policemen are only trying to detain the person using the the primature of the law to keep the person and commit illegality. So once you are aware that they've taken the person to a particular court, you as a lawyer can go to that court at the return date and insist on speaking on behalf of your client that the court should grant the client bail, conditions that the client can meet and come out, and you report it to them even they want him to report it every day. At least let his liberty be secured. So you see, the truth is that we have a situation where we have good laws, but bad people implementing those laws. And we also have laws that, the rights that we can exercise, but even the client does not even want you to exercise those rights. There are instances too where you have a client who you advise as to what he should do to get his freedom. He will tell you, don't worry, we are going to relax it. I don't want them to be angry. I don't want them to charge me to court. But I would rather that you tell the client, let the matter go to court. If you know that we can defend your innocence there, let it go to court. At the end of the day, yes, you spend some money proving your innocence. At the end of the day, you will be free. But I agree too that with Ms. Zeke that where it is now clear that the police officers are or any of the law enforcement officers are engaged in an act or a preconceived act, the proper thing to do once it is clear to the practitioner is to exacerbate the issue and escalate it to the next level, either to a superior officer or write if it's like a police formation, to the commissioner of police to look into the matter. If it is one of those law enforcement agencies like the EFCC or ICPC, it's either you are writing to the chairman or you are taking the matter to court. Let the court have a look into what is happening. And I tell you something, most times when you take this matter to court during the course of investigation, they have to come there and explain. And the moment they are explaining to the court why they are keeping the man beyond a certain number of days, the court would strike an acceptable balance between keeping the man and getting his freedom. Of course, that's going to be a good situation, a good outcome for the legal practitioner. At the end of the day, it's all about us having recourse to existing laws and existing measures and hoping that we can get the best for our clients, as it were. I also agree fully with Professor Nasiru and Dr. Agaba on their own contribution. But I don't agree with him that I spent up to 1 hour.
You just made it up with this correct defense. Thank you very much. I'll now invite, we have about 43 questions on the question and answer box. I'll invite Ms. Mebele Keke to take us through question time. Mabel. Tola, I didn't even see you. Tola, did you have any comments? That's it. Tola should be sorry.
No, I don't. I enjoyed the presentation thoroughly. I'm satisfied.
It looks like you have my temperament of not accommodating police very much. So people in our school will enjoy it. Okay, thank you. Mabel.
Thank you very much, Mr. Chair. May I stand on existing protocol respect to our facilitators and our colleagues? I'll run quickly through the questions. The first one is from Mr. Joseph Toriola. He says, great presentation, sir. In a situation where a client is invited to a police station and they refuse to disclose the reason for the invitation, thus as a lawyer, you do not know the petitioner, neither does the client know the petitioner. In doing so, you will not be able to prepare your client for possible question during interrogation. How do you handle the situation during this process, most especially the questions to your clients?
Okay, thank you very much. I saw that when I went to I must confess, I ran to the Q&A when I saw the questions growing by the day. I ran there to go and find out the kind of bumps I was going to face. You see, for me, using myself as a case study, once a client tells me I've been invited by either the police or a law enforcement body, the first question I always ask is this: can you just, in your mind's eye, go through your activities and tell me why you think you are being invited. Oftentimes, you discover that if the man makes 5 guesses, it could just be one of them. That's why I said different scenario. Nobody just comes out of the blues and say they're inviting you. If you're a banker, for instance, it could be because of certain transactions that has happened in the bank. If you're a businessman, it could be because of certain transactions you've done with somebody. Maybe you don't have the particulars of which of the persons have reported you. But that is not always most times correct, because sometimes the person who wants to report you must have been engaging you. If like it's a business that has gone awry, it would have been engaging you, and you, of course, it would have been threatening to say, I will take this matter up. And that is the most common of the incidents that go to say place like, say, EFCC. You do a business with somebody, he assumes you duped him, and because he didn't get the benefit, he worries you over a period of maybe 1 year, waiting for you to do the right thing by him. Maybe during that course of that period, you do 1 or 2, you release 1 or 2 monies to him, but it's still not what he expects. And then along the line, you receive an invitation. Obviously, it doesn't take, what do you call it, rocket science to link that event to why you have been, unless, of course, you are involved in a daily issue of habitual things that one can say can cause somebody to invite you. However, let us take the worst case scenario as painted by the question, in the question, which is you don't even know, your client cannot even hazard a guess as to why he has been invited, and you don't even know. The first thing that happens whenever you go to such a place is that they will give you the petition to read, or they will read it out to you and tell you why you have been invited. I always, at that point, after establishing close relationship with the policeman, what I do at that point is to say, can I have a moment with my client so that we can discuss this? We're not going anywhere, we're just there. I just want to, because we never knew why you invited us. We're not going anywhere. Nobody is going to say, oh, no. He's here, nobody does that. I can tell you, it's all about your approach. Don't make it seem as if it is a right you are demanding. Just say, let's have a moment with him, because there are, you might even put it this way, there are documents, he has seen the petition, there are documents that will aid him in responding to it. I want to have a discussion with him on those documents. That's why you are there as a lawyer. That's why you are there. The reason you are doing that is because you want to have a minute with him to be able to say, okay, what is his response to this? If he says this, you can give him maybe a few ideas of how you expect him to answer. It may not be the most effective way to represent him because, of course, you needed time. But at least you will have the opportunity of telling him, okay, if this is why they're inviting you, tell them that this is what, try and avoid this and just give them the full picture and say that you have documents you are going to bring. If you look at some of, if those of us who are conversant with the criminal trials, we see that in some of the statements that are made by the defendant, you will see where they've written that I will bring documents later. It's always, most times you see things like that. It means that at the time the man was making that statement, he did not have the documents to support his own position, which that's why he said he's going to bring it. That opportunity of bringing it means that when you come back and present those documents, you still have an opportunity of writing a statement. Obviously, if you go out and you're allowed to go and bring it, which they will also allow because you get admin bail, you cannot settle down on preparing a proper response that would not be too much in conflict with what he has said, because you don't want also to be seen to have said one thing the first time in the presence of your lawyer, then you do a 360 the next time. It's really, you are representing your client for conviction during trial. So you must learn to have a tight story that is running through and is coherent or true, not you say one thing today, you say another tomorrow. So yes, there are instances where you may not be able to have that opportunity of knowing why your client is invited for you to be able to prepare properly. But those instances, you should be able to make good use of the little opportunity you can when you see the petition against him to demand for a little bit of time to discuss with your client on those allegations, because some of the documents that your client, if he had known this was why they invited him, are maybe at home or he could access them, is what you now want to discuss with your client so that he would be able to properly respond to their question. So that would be my simple answer to that. I hope it's satisfactory to the person who asked the question.
Thank you very much, Doc. Barbara Magaji says, as I engage with police officers through trainings and capacity building, it seems it is a mirage for the system to expect police officers to invest before, or to investigate, maybe that's what she meant to say, before conducting an arrest. Is this possible with the current state of the Nigerian police? The police complain about poor investigation method, sources, etc. I'm sure she would want your comment on this.
Well, that is a police service commission issue, really. For me, every policeman will tell you that they are poorly paid, they are not well taken care of, and all that stuff. But what we are discussing in this seminar and the training here is for how lawyers should approach them in getting their effectively carrying out their job, not about their welfare, really. Yes, their welfare could be tied to why they are always angry. A man who is not well taken care is always angry. So, I mean, that is possible. But I also believe that the proper thing to do, and this, I must commend the law enforcement agencies like maybe the ICPC and the EFCC. I know that before they invite you, you are the last in the chain of investigative actions. So once an allegation is made, they start investigation, getting all their materials together. So when they invite you, you are the last in the chain of events. They've done so much to be sure that you are supposed to be invited. At least I know that for the ICPC. I also know that for the EFCC to some extent. What I would not be able to say for the police is whether they even investigate before they invite. Most times, once you just come and complain, they say, where is he living? Okay, you go and bring him. Because they are closer to the people and the nature of their job is to ensure that they instill peace and order. Maybe that's why they do all that. But proper investigative bodies don't come and arrest you first and then start looking for paperwork. What they do is that if it's an allegation of, say, fraud or anything, maybe obtained by false pretense, they get the complainant's version, get your statement of accounts through your bankers, those things you are not even aware that they're getting those information, your companies from the CAC, records and everything. So when they are asking you questions, if you are contradicting yourself based on the documents they have, they already know you are lying to them. So I always advise, don't tell your client to just say no to questions that are very, very easy to verify. I mean, you are asked if you know a particular person, you say no. I mean, while the person has been invited, he has even made a statement about your relationship. So I think investigation by police officers, if I'm going to now answer the question directly, is a matter of individual style. The officer, if he's motivated to work, would work. The one that is not ready to work will not work, even if you pay him all the monies in America. He does not really know why he's a police officer. Those professional police officers or professional investigators, they will do their job. If there are hindrances to doing their job, perhaps it could be like logistics, for instance, to go to a particular place to be able to get a particular information. By the system we operate in this country, which is not the ideal system, I know that most times the people who complain may provide those logistics. I know they do that so that they can be able to get what they need to do their job properly. But of course, the Police Service Commission, I'm sure some of the people who work there who are lawyers and logged on to this webinar, they should be able to take back that to them to say, look, we need to do an improvement on what our officers investigate. Thank you.
Thank you very much, Doctor. A lot of positive feedbacks. Thanking you for your intervention. Akintunde Otubu says, must the letter of invitation by the police state and give information on the subject matter of invitation? What happens where the particulars are not included in the invitation? How does this impact on the ability of counsel to offer effective service? And how should the counsel handle it?
I think in answering that first question, I answered this one, which is like you are not aware of why they are inviting you. I think they are just related, just that asked in a different way, if you don't mind my saying so. It's the same response, which is get there and a petition will be shown to you, take a look at it, request for time to bring in proper documentation, and come back and answer. An investigation is nothing if you cannot provide answers to questions. So if the answers to questions reside in documents that you can use to boost your position, documents like we all know as lawyers, they say are the angle on which to test oral evidence. So if for any reason you have documents that prove a lie to a particular petition, I think asking the police officer or even the law enforcement investigative officer that I need time to go and bring all these documents. I didn't know this was why you invited me. I'm ready to come back the next day or 2 days later with all these documents. I think it's a request that most times they grant. It's for you to come first to be sure that you've submitted yourself to the authority and you do so with the humility that I've preached before. That matters. Subsequent requests to go and come back to now answer properly, I don't think they usually deny you that part, unless, of course, there are issues beyond the normal investigation, which, of course, you can address at that point.
Thank you. I think it's important to clarify for Mr. Chikas. He might be mistaken a little bit here. He says most time the invitation letter does not contain the details why the person is being invited.
Yes,
how do you tutor your clients? And I don't recall you saying that tutor clients. So I think it's just important to share.
I did not say
what to say or what not to say in the circumstance.
I thank you very much. And let me just say that most invitation letters is correct. They just say they're investigating something, they need you to come to throw light on what they're investigating, meet so and so person or so team, and all that stuff. I think that's what they do. They don't tell you what. It's you that will discuss with your client to say, look, what could be the possible reasons they are calling you? That's why I said you and your client will engage in several scenarios. And then, of course, you work on each of those scenarios so that when you get there, you're able to give an answer without you interfering with the process.
Thank you. Joseph raises a question here. He says, generally, bail is free. The police says the condition for bail is not free. So practically, how do you negotiate the amount you give?
I don't think that's what's under the part of the job that I bail is free according to the law. Whether something is paid behind the scene, I think that is every individual's style of doing job. I think before you get to that point, the things you need to do to get to the point where you are even in a position to be discussing such things is what I dealt with in my presentation, which is creating a sociable environment and rapport that would even make the man feel confident to say, okay, you know what, we'll release your client, maybe you do something. I'm not going to get into that part because obviously it's an illegal act and I don't want to be seen promoting such things.
Thank you. Yusuf Tanko says, I appreciate your frankness and simple approach. I can see some enough efforts are made to prepare lawyers during client interrogations. What efforts are made by NBA to educate the normal, arrogant Nigerian police to be user-friendly to the lawyer/suspects in the same circumstances?
That one is for Tobena, not me. Tobena is NBA representative here. Tobena, Mr. Chairman.
So what was the question, Docs?
They asked one question. I've asked Mabel to send it to you.
Yes, Mabel.
It says, what efforts are the NBA making to educate the normal, arrogant Nigerian police to be user-friendly to the lawyers or suspects in the same circumstance?
So I think that just listening to Doc's presentation and the comments that were made by some of the other speakers, including Professor Nasir Al-Yusan, it is obvious that what you have in Nigeria, the criminal justice system in Nigeria, is very different from what is obtainable in most other places that are civilized. And so I think it is within that context that Doc's presented his paper, that we have an obvious peculiarity as to the way we do things in Nigeria and the way the police force is wired. However, it is because of this that under the administration of Olumide Abata as president of the NBA, he set up the Security Agencies Relations Committee, which was headed then by Joe Gatam-Hassan. And then subsequently, this administration has also set up a new committee of that nature, so that we continue to interface with the police force and try to make them understand that we're all partners in the type of work that we do. I mean, a lot of effort was made to bring the ACJA and now the ACJL of different states into place, and then to also focus on having them implemented. The MB and MacArthur Foundation actually ran a collaboration, which was subsequently extended to the training of police officers around the provisions of the ACJA and then the ACJL of different states. And I was part of that initiative and that training. I've also, the current president of the MB, have also introduced discussions with Solomon Arase, who is the chairman of the Police Services Commission, and I'm supposed to be part of that conversation around training and collaboration so that Nigerian police officers understand what their roles actually are. But it's a long way to go, and I'm sure that every effort is being made for us to get to where we need to be on that one. So I think I've said a little bit today. We'll go back to Doc since it's his day. Thank you.
Thank you. Doc, this is for you.
Yes.
Fabian says there are instances in which an invitation is given by the police to a suspect who does not know the reason for the invitation. How does the lawyer then prepare a suspect for this? Secondly, is there a limit to the number of lawyers who may be present on behalf of the suspect in interrogation?
First question, I've answered it twice now.
Yes, you have. Yes.
So I presume the person was listening, so I will not repeat myself, so I can take other question. Second question about the limit to lawyers. I think it all depends on the space available for them at the place, really. My experience has been that all of them cannot be talking at the same time. We have order in our profession. There's a lead lawyer who will take the lead. All others, of course, would just sit by and while the lead lawyer takes the lead. If there is space for them to sit the place, fine, they can stay there. If not, I think they should go back to the office doing something more productive. But the bottom line is that the law presumes that the client has a legal practitioner present, not legal practitioners present. So I would suggest that that should be individual choice to make how many lawyers you want present. So that's my simple.
Yeah, thank you. Agogo says, is it possible to make notes on any observation while you're watching interrogation, like put it down on a paper for use afterwards?
Of course. You're taking notes of what is happening has nothing to do with interfering with the investigation. You are there to do your work, just as the police are there to do their work. What I only advise is that don't be seen as somebody who is there to create a clog in their own wheel of investigation. So if you take your note innocently for purpose of discussion with your client later, or even engaging the IPO directly later, because I have done that several times where I do not agree with certain things, I would meet the IPO privately and say, look, this matter, this, look at this. I'll draw his attention to certain areas I believe he is not really averting his mind to. This is part of the interaction of building rapport that I was talking about. You must get to a point where he doesn't see you as a threat, such that if you now make suggestions that are useful to him, he will go that direction. I've had even course at the Lagos State Police Command to buy a magnifying glass. I think that was maybe sometime around 1995 or thereabout, if I recall, or 96, where we had some kind of paper that was very blurred and everything, and the policemen were trying to. I said, look, I can't rely on this. I went and bought a magnifying glass. I used it to look at it, and then look and say, look, my client can't be in any of these things. And of course, they took the magnifying glass from me at the end of the day as their own equipment. I was glad to give it to them. But that is the kind of intervention that is positive, not the type that seeks to just be disruptive. That's the point I'm making. So you can take notes.
Thank you. Would you say that when a lawyer is in a police station for a client and is trying to keep it respectful, the police often tend to see the lawyer as being timid and ignorant of what to do as a lawyer. They tend to fear or listen more to those who threaten them and make so much noise. What should a lawyer do in circumstances?
Well, I think this is the opposite of what I've just been preaching, which is be calm, be respectful, be firm. If you look at one of the slides, you see where we put there that you should be subtle, calm, firm, and I think there was another word we used there. But the entirety of our presentation is that you don't want to be seen as somebody who is going there to lord it over anybody. There is their office. And I just gave an example of what can happen. You can be present without being present. And this is the way they do it. This is the table of interrogation. Your client is sitting on a chair. You're supposed to be seated beside him while they're asking him questions, and you are watching the event. If they see that you are a threat, in order not to be seen as removing you from the process, they will put you at one end of the office. You are observing what is happening, but you are not there. The alternative for you is that they will remove you from the place. But they will tell you, I don't want you to go and report tomorrow that we kicked you out. So it's a large hall. You are seeing what we are doing. We're not beating your client. So sit down over there. So how effective can you be when you are far from your client in that respect? Those are very subtle ways they deal with you as a lawyer, and you can't go there and be fighting. So I don't agree with the person that it is those who make noise that appear to be more effective. On the contrary, I believe there are a lot of silent lawyers, if I will use that word, who operate silently more like, and they are more effective than those who make all kinds of noise. In fact, once you are seen as that kind of person, from the gate, that's where they start dealing with you. So I will say that keep your calm. I'm not saying, again, and this is very important, I'm not saying that when the need for you to be firm and to rise up to be firm, that you won't do it. No, of course, you're a lawyer, not going to be timid all the way, but let it be seen that you have exhausted every courteous approach. And when you are trying to be firm, you're even doing it in a respectful manner. And you get the desired results. I don't recommend at any point for you to go to a police station or a law enforcement office and start shouting at people there. It's not done. That's a public office. In fact, if it's police station, policemen, they know the law to deal with people. They will just tell you that you are breaching public, what's that word they like to use? Public peace. And tell you to sit and wait behind the counter, because obviously that's what breaching public peace is, an order.
Thank you, Doc. Shegun would like to know what your take is. He says some counsel are in the habit of paying shorty, and on the court dates, they are nowhere to be found. Then ask the law enforcer to go and look for his clients and then arrest him.
I don't know whether I understand that question. Is it saying that lawyers pay for shorties who abscond and they make the lawyer go and look for the client? What is it? I don't understand.
It's unclear.
Well, I don't know if I should ask. If I'm to hazard what he's trying to say, whether they will arrest the lawyer for the client, that if the lawyer is the one who took the client on bail, he's the shorty then. Or if he's not the one, and the lawyer paid somebody according to what I think he's trying to ask, to act as shorty. The problem is not the paying the shorties to act as shorty. The problem is for the defendant not to appear when he's supposed to either appear in court or at the police or law enforcement agency office. That is where the problem is, not the act of paying. Whatever business that is between the client and those who stood as shorty for him, I don't think is within the scope of my discussion. What is important here is that whoever is acting as shorty should be somebody. I always request my clients to bring somebody that is known to them. That way, we do not have a problem with saying that we are looking for anybody. And I think that the law enforcement officers have the appropriate mechanism of dealing with such situations where there's an absconding defendant tied to a shorty. So I think they will have recourse to that. The question is unclear, but I think I've attempted to see if I can understand what he's trying to ask within the best possible way I can do that. Yes.
Thank you, Doc. This is another one here. He says, You said if the suspect had given a statement, you can request that another statement be taken from him, which you can sign as a. Will the law enforcement agents oblige us to allow the suspect make another statement?
Well, the person did not understand what I said.
The context.
Yes, did not understand the context of what I said. What I said was that I tried to draw two scenarios of you are representing a client during the interrogation process. First is that he's been arrested and perhaps he has made a extrajudicial statement before you were briefed. So he's under detention, you go to see him and then ask him what really happened and he tells you his story. And of course, tells you that he's already written a statement and that statement is not in alignment with the story he's told you. Obviously, it means that something happened when he was not represented. That's why he wrote a statement that seems to be disproportionate to the story he's telling you. Now, in that kind of circumstance, because you are just coming to the matter, you don't want to start being seen as making a whole lot of noise that will create problems for you. He's still in detention. The reason he's still in detention could just be that they want to still get a second statement from him. Now, maybe that's where I did not clarify that, made the person to ask the question the way he asked it. Most times, during investigation, you see suspects that's defendants making first, second, third statements, sometimes up to fourth statements. What I was saying is that from the point that you are now representing him and having heard the story and know that he made a statement that does not align with what he's told you, tell him that, tell the client that he should insist on not making any other statement until his lawyer is present, now that you've introduced yourself as his lawyer to the investigative officers. So at that point, if he's to make any further statement as a result of investigation that they have now done, maybe having further investigated this, need to seek further inquiry from him, you can sit down there, prepare him, already you've prepared him, of course, on what he needs to now do, having told you his story. You sit down there, he writes his extrajudicial statement, you cannot suggest to them that, please, since I witnessed this, I would like to sign as a witness. Most times, like I can say it for the EFCC, they always feel happy when you, as the lawyer, sign that portion. So you sign it. Now, if the first statement that you did not witness, which is complaining about, becomes an issue during trial, and a trial within trial is now being done to resolve the voluntariness or otherwise of that statement, the fact that you witness and sign the other statement would go a long way in weighing on the mind of the court as to the voluntariness of that first one that seems to be in sharp contrast to the ones that you witnessed and signed. So it simply would put the court on notice, on inquiry as to why is this so and why is this one so. Another thing again, you have a short statement, for instance, of about 1 page, and you look at the time the statement was taken, maybe it's 1 p.m., and the time it ended, 4 p.m. Obviously, there's something wrong with that process. You can, no matter how very problematic his situation is, will write a 1-page document for 4 hours. So those are commodities you bring to the attention of the court, ensuring that there was serious issues going on that made the man to write a 1-page statement that maybe does not consist of more than maybe 5 paragraphs for over 4 hours. So that's just what I meant, not that I said you insist and write another statement. Obviously, if there's no other statement, you can challenge it during trial.
Doc, this is interesting. With all you've explained, it's apparent that you're speaking to emotional intelligence. But listen to Bulus. He says, the basic understanding lawyers need to have from today's seminar is, when dealing with security agencies, we need to do so as solicitors and not as barristers. So the need to employ tact as taught by the key speaker is paramount. In most cases, lawyers deploy their combative and explosive side, citing statutory and judicial authority, a character meant for the courtroom. I think that's not exactly the point. I think barristers also can have emotional intelligence and do have emotional intelligence where it's required. So I would like to just make a clarification as to this. Would you think that there's a distinction with how barristers or solicitors rely or utilize these soft skills that you've spoken to today?
Okay, I think I would take it from the point of view of the fact that we all as lawyers know that solicitors, the nature of their work is more of engagement with the client, taking instructions in the truest tradition of the word solicitors as it is seen in places like, say, UK, where you have a distinction in the practice. Barristers go to court, and the solicitors are the ones who engage the clients, and barristers are engaged by solicitors to go to court. So if you look at that from that prism, you discover that maybe that's why the person who has the question is put his position in that manner. I will not say that barristers don't have emotional intelligence. Of course, that's not correct. I would rather say that I believe my friend who asked the question or who made the comment wants people to see that, try and understand that there are two sides to the law practice. When you go to a place like the police station, don't take it that you have gone to court where you are going to deliver arguments, make positions of law known to the judge, and then sit back and the judge will give a ruling where you are forcefully in your position. The more you are able to forcefully push forward your views, that's the more convincing they are. No. At the police station, you require another kind of lawyer. You require a lawyer that is calm, social, personable, free with people. It gets more results. You require a wheeler dealer or something. Yes, you require such a person. I think that is what he meant. I believe that's what he meant. I don't think the emotional quotient is what. I don't agree with him to that extent, but I believe that he meant no harm by the way he said it.
Thank you. It seems to have been a tradition that once you have been invited to the court, you must be asked to be taken on bail, even in a simple contract matter. Is this the right approach?
Please say that again.
It seems to have been a tradition that once you have been invited to the police, you must be asked to be taken on bail, even in simple contract matters. Is this the right approach?
Well, the truth is that once you make a statement under caution, you see, that's the part where although it's not part of what I said here, but now that the question has come up, I will probably make reference to it. You see, normally when you engage with an investigative officer, either police or any of the other law enforcement agents, before you make a statement, having now understood why you were invited, or having been told why you're invited, and you've explained your own part of the story, it ought to give the investigator an idea as to whether you are a suspect or you are somebody who has just come to throw more light on the investigative process. This will determine the form that will be given to you to make your extrajudicial statement. If they give you a form that does not contain the cautionary words, there's no need, they will not request for you to talk about bail. I think most lawyers don't seem to know that part, that if they don't write the cautionary words on that form, it means that they are just obtaining your story and you are at liberty to go after that exercise. But the moment they say this thing you are writing, and you don't have to write anything, but if you write it, they will use against you. That's the cautionary words. Once they write that down, I can assure you that the next step is you must apply for administrative bail, because it means that you have been arrested, so to speak. For want of the way to describe it, you have been arrested. So now you need to put a condition down, satisfy a condition that will ensure that whenever they want you, you come back. So those are the two distinctions. Now, the police and other law enforcement agents serially abuse this opportunity, because not every time you call somebody and he has something to say that he is linked to the crime, but because they want to be able to say that they took your statement under caution, they now make you do so. And then, of course, the issue of bail now comes in. Unfortunately, we have to deal with those situations as a country. We are hoping that as time goes on, and I must confess too that a lot more educated people are getting into these police forces and what they call them now, the law enforcement agencies. I believe that with time, maybe in some years to come, some of the practices that we are seeing now will be a thing of the past, because newer engagements and innovation, like Tobena mentioned, the NBA is engaging the police, and I'm sure the Arase, I think Arase, the new police service commissioner, is a lawyer, I think. Yes, he's a lawyer. And I know that with time, when we engage them, they should be able to begin to change the process so that the methodology of investigation and engagement with people, either as people have something useful to say in the investigation or as suspects, will become clearer. And then the appropriate action that they should take should become much clearer. So you know that you are not going to be arrested unless, of course, there's need to arrest you.
So there's a question here from Zulia, and she says, is it the law to detain a person upon being invited by the police?
Is it unlawful to?
Is it the law to detain a person upon being invited by the police? Should it follow as a matter of course?
Not necessarily. That's why most times now they give you condition for bail. But you see, it is your inability to meet the condition that makes you to be detained. And it's deliberate in certain instances. And in some instances, when they look at the kind of person, even when you don't meet the condition, like I said this before, when you don't meet the condition, because of the rapport and maybe the person and the nature of what they're investigating, they just tell you to go. Maybe anybody that can just take your bail will just go. They will not look at those conditions. But if it's a very serious matter which they believe that they need to be sure that somebody will take responsibility for you, then of course they will detain you. But I think things are not as bad as people assume that they are when they are dealing with certain law enforcement body at a certain level. The reason we are having some of these challenges and bad impression is because it's still the police. You see, the police, they've not cleaned up their act the way a body like ICPC will clean up their act. Let me even explain. ICPC as a body, I'm sure Dr. Onodja is not here. I would have said he would have supported what I said, at least throw more light on it. You see, ICPC, my experience with them is that when they want to go to take you to court after filing charges and everything against you, they inform you that, look, come to our office to pick up the charge sheet containing the proof of evidence. They tell you the courts that you're supposed to go and the dates, because it's all written in the paper that they're giving to you. You are expected to be in court on Monday. This is the charge sheet. Goodbye. Nobody disturbs you. You just go straight to home, go and look for a lawyer and discuss it, and then go to court and he starts doing his work of applying for a bail and all the rest from the court. But EFCC, I don't know if they've changed their practice, but it's still, to my knowledge, that if they are going to charge you to court on Monday, they call you this week. The moment you come, they'll keep you till that Monday and take you to court from their listing. These are some of, you can look at if you look at the way they started, the ICPC had its first chairman as a retired judge. The PFC started with a policeman. So you can begin to see their attitude. The ICPC grants you administrative bail. The EFCC grants you administrative bail. You get to court, the EFCC will challenge most times your bail. The file counter affidavit challenging the granting you bail. But ICPC will tell the courts it's at the court's discretion, because they already granted you bail. If you wanted to run, you can run. There are ways to bring you back. So it's all about how the orientation of any organization, really.
Thank you. So I must say that we've had quite an interesting conversation today, because the questions keep rolling in and we're short on time. We have over 36 questions here. Some of them are quite elaborate. If you don't mind, I would suggest that we post your email address so that they can reach out and engage you or seek your views on some of these questions. But I'll try and take the very short ones, maybe just one or two now, so that we can then wrap up from here. Ifeanyi says, how can one navigate a situation where a police officer is acting outside their legal authority?
He has to be more specific as to what he means by legal authority. The police officer that has arrested you is acting with this legal authority if you have done something that's worthy of arrest. If you have not done anything that is worthy of arrest, of course, that's a different thing entirely. There are ways to address those issues. But I believe that he probably meant that when you try and do all that you need to do to ensure that you are effectively carrying out your job as a lawyer, a police officer is acting in a manner that is in contrast to your expectation. If that is what he meant by the question he asked, I would rather say that the answer to that is simple. Like I said before, I gave an example that if the investigating officer, who is the first port of call in the course of the process, which is the subject of this discussion, he already has an agenda, maybe with the complainant, to ensure that they frustrate any ability for you to get bail. Even once you realize that, don't make it known to him you've realized that. Because the moment you make it known to him, you guys will go into some kind of altercation, and you don't need that. So try and pretend as if you're not aware of what he's trying to do, and rather seek his assistance to know how you can overcome this. No way he's not going to give you that assistance, but it's all part of the game you are playing with him. It's a chess game between the two of you. You are trying to use your superior intelligence to make him see why he will not succeed. And the way you have to do that is to make him believe that you are not aware of his role, and then approach his superior and explain to that superior that this is what has happened. The man has been wonderful, but you are unable to meet a certain condition, but you can meet XYZ condition. How can he be of assistance? At the end of the day, you as a lawyer, you are committed to seeing this through with your client. Now, obviously, the superior officer will call him or ask for him to be called over. And then if he comes and he starts throwing tantrums the way he's been doing with you before, contrast it with what you said about him to the superior officer. It will be very clear that something is amiss. And at that stage, the superior officer will take a decision, because at that level, I think at that level, the policemen there are much more reasonable in terms of the way they evaluate situations. And an accord can be reached as to what you can do and what they are demanding from you. You will still get your results at the end of the day, which is what I would advise.
Thank you very much. Nigerian wants to know if a lawyer has a role in the production of a shortee.
Well, it's individual choices, really. If you know that you can provide people for your clients, I would rather that is something that you do without advertising that is what you are doing. I mean, to the persons that are going to evaluate their fitness to act as sureties, because sureties are supposed to be persons known to the suspect. Now, if for any reason the suspect is unable to provide such persons, before you get involved as a lawyer in that process, you should also ask yourself a simple question. If anything happens, will there be a fallback on you? If there will be a fallback on you, I would rather that you don't even get involved, because every time you go to that police station and do or that law enforcement office and carry out any exercise, it is the success of it that determines the kind of relationship you're going to have in the future when you go back there. You have to go back there in the future. And if you are remembered as somebody who acted honorably and favorably, I think it would also impact on the next client. So I would not advise that the lawyer should provide surety, neither would I advise against it. I would rather say that let the circumstance of each case determine what the lawyer will do at the appropriate time.
Thank you very much, Doc. I would lend my voice with all our attendees to thank you very profusely for the presentation. It's been quite insightful. I think you should take a little time and read some of the comments. Our participants have indeed been very grateful. Thank you, Chair, for this opportunity. I'll hand over to you now.
Before making my closing remarks, I just want to say that I've seen a lot of comments regarding slides. And I want you all to know that we usually circulate all the slides from every training session to all the members of the NBA, whether they attended or not. And so you will get those slides. Also, more importantly, is the fact that all the recordings of our trainings are on Nigerian Bar, the YouTube channel, Nigerian Bar Association HQ. So you can also go in at your leisure and watch again the program. Thank you very much. Well, we've come to the end of today's presentation, and I will say that what a practical and incisive session today's session has been. Very interesting, very illuminating. And this is exactly the type of training we expected it to be. Very practical. And I mean, when you listen to this kind of presentations, the tendency is to think, how did he put it all together? Because they're not textbook materials, but it's because the man does it every day and understands it. And I've learned a lot myself from it, because I have very little, and I've seen a lot of people say, what about the pride of the lawyer? What about the ego of the lawyer and all of that? And it's easy to see why Docs has learned to deal the way he deals with the police. And I think that it tells us that there is the level, type of emotional intelligence required for every situation. And that at the end of it, I think the most important lesson from this is that you must put your client first. And in putting your client first, you must act in his best interest. And I think that is the primary training that we get as lawyers, as people who represent people and are advocates. Docs, I must say a very big thank you to you for the time you spent in the last 4 months putting all of this together. Yourself, coordinators and the rest of them, but you've been very, very, very helpful. You've done a lot in terms of guiding the entire process, yourself and Professor Nasir Ali especially. I thank you very much for your time with us today, and I thoroughly enjoyed myself. Thank you, Docs.
Thank you very much. Thank you very much.
Yeah. And then tomorrow we are back here again at 2 p.m. Tomorrow will be a session with Professor Nasir Aliyu, Senior Advocate of Nigeria, who is also a member of the Board of the Institute of Continuing Legal Education. He will be speaking to us tomorrow on charges. And Prof, I saw that a lot of your students from law school were already excited.
Yes,
to see you.
Prof is a superstar here.
So, Prof, they'll be waiting for you tomorrow, and I'm also waiting. So, thank you very much. Thank you to you, Dr. James Agaba, for joining in today. Your comments were quite helpful. Thank you to Mrs. Eke for joining in. Thank you, Mabel. Thank you, Tola Oshobi-san. Thank you, Tola, for all that you do. Very grateful. And thank you, distinguished delegates, for participating today. Do please help us continue to circulate the materials from around and from this training so that other members get to participate and learn. We're all knowledge merchants, and there can be no end to learning. I remember that even paying, I've learned a few things today, so I'm not going to dodge any criminal matter that comes my way that I had the tendency to dodge before. So thank you, ladies and gentlemen, and God bless you. Bye-bye.
Thank you very much. Bye.
Thank you, Mr. Chairman. Thank you very much.
Thank you, Doc.
Thank you, Doc. Thank you, Prof.
Prof, hand over to Professor Nasiru for tomorrow then.
Prof, I don't start now till tomorrow. We are here.
They said I was on hot seat. Prof is going to be on the top of the fire tomorrow with all this.
Not your own cold seat today. You handled it with such dexterity that the hot seat became very cold. Thank you. Thank you.
All right, then. Take care, everybody.
Thank you.
See you guys tomorrow. Thank you. Thank you.